Welcome, everyone, to another lecture from the Arizona State University LDNS Lab, Leadership, Democracy, National Security Lab here in Washington, D.C. We have an audience as well as a virtual audience, and this will be posted ultimately on the ASU website. What we're going to do, I'm David Sheffer. I'm a professor of practice at Arizona State University in the Washington, D.C. LDNS lab world. And I think some of my students are here tonight. And I welcome everyone, including a crowd from Tempe, Arizona in particular, the main campus of ASU. We have a very, very special guest tonight to speak. And I just want to tell you what the drill is. First, I'm going to introduce him. He's very modest. He said, "Don't say anything about me. I'm going to say something about him, and you're just going to have to endure it, okay? Because you need to know where Eli is coming from in life." And then secondly, Eli's going to give remarks for about 30 minutes or so, or even longer. And then we're going to have some questions between him and me at the seats there. And then we're going to open it up for audience questions. We have a mark of about 6 p.m. Eastern time to end, generally, probably maybe 5-10 minutes later, who knows. And then for those of you who are here, luckily, in Washington, your mini dinner is behind you there. So please take advantage of it, because I certainly will be. I want to introduce Eli now to you. Eli Rosenbaum retired last month after a 38-year career at the United States Department of Justice, where he led the investigation and prosecution of a broad range of human rights violators, from World War II Nazi criminals to Rwandan genocidaires and beyond. Under his leadership as director of the Justice Department's former Office of Special Investigations from 1995 to 2010, his office won more cases against Nazi criminals than did the governments of the rest of the countries of the world combined. He subsequently served from 2010 to January 2024 as Director of Human Rights Enforcement Strategy and Policy in the Justice Department Criminal Division's Human Rights and Special Prosecutions section. He, in 2020, in the most recent World War II Nazi case he personally tried, a new U.S. cold case record was established for the longest time span, 75 years, between the commission of crimes and those crimes being proved against a defendant in a court of law. And in June 2022, and this is in our real-time life here in Washington, Rosenbaum was appointed by U.S. Attorney General Merrick Garland to serve as the Justice Department's first ever counselor for war crimes accountability, and to head the agency's newly created War Crimes Accountability Team, WARCAT, to coordinate the department's efforts to pursue accountability for atrocity crimes committed in the wake of the full-scale invasion launched by Russia earlier that year against Ukraine. And in December, WARCAT's efforts led to the indictment of 4 Russia-affiliated military personnel for war crimes committed in Ukraine, making the United States the first and still only national jurisdiction other than Ukraine to prosecute alleged Russian war criminals. Now, he's a graduate of the Wharton School of the University of Pennsylvania and of Harvard Law School. He has a list of awards, which I'm definitely not going to read to you. Eli, you might be able to identify the website where there are the 300 pages that have your awards all listed on them, and then they can check out all of the awards you've received in life. I think the one he's most proud of, or at least very proud of, is in September 2023, Ukrainian President Vladimir Zelensky awarded to Rosenbaum the Order of Merit, conferring the title Chevalier of the Order of Merit for support he has rendered to Ukraine's pursuit of justice in the wake of the Russian Federation's aggression, war crimes, and crimes against humanity. And finally, you want to check this out on Amazon, his 1993 book, Betrayal, The Untold Story of the Kurt Waldheim Investigation and Cover-Up, recounted the investigation he led that resulted in the worldwide exposure of the Nazi criminal past of former UN Secretary General Kurt Waldheim. And it was selected by the San Francisco Chronicle for Best Books of 1993 and by the New York Times for Notable Books of 1993. So I have no apology for reading all of that to you because I want you to know about Eli. He's an old-time friend. I've had a 30-year professional relationship with Eli because he was there when I first entered the State Department working for Madeleine Albright, at that time our ambassador to the UN, and then ultimately as Secretary of State. And just was very proud to sort of march arm in arm with Eli through so many different situations that required justice during the 1990s. And we've kept together since then on other issues. So Eli, the floor is yours.
Thank you so much, David. I should tell you that my understanding of the status of Chevalier is it means I'm a Knight of Ukraine. And I tried that on my wife. I said, I think you may need to call me sir. No way. I said, how about Chevalier? No chance. And I thought, okay, how about compromise at Chevrolet maybe? But no. Anyway, it's a very special privilege and really a thrill to be introduced by one of my longtime heroes, someone who's been a brilliant and truly indefatigable leader for decades now in crucial efforts to end impunity for the perpetrators of genocide, war crimes, crimes against humanity, torture, and other international crimes. God bless you, Dan. I've been asked to discuss the subject of law as a deterrent against the commission of international crimes, particularly based on my 4 decades investigating and prosecuting the perpetrators of such crimes from Hitler's Germany to Putin's Russia. For the benefit of students considering possible career paths, perhaps in the Q&As, I can be asked to recount, if you're interested, how, to my great surprise, I ended up devoting my career to working on human rights cases. That was not the plan going in. But let's discuss deterrence. At the outset, I should note that although deterrence, along with punishment, protecting society through incarceration, and rehabilitation are the principal goals of law enforcement everywhere, it's traditionally been very difficult to prove the extent to which law enforcement, at least when practiced humanely, with proper respect for civil rights and human rights, yields deterrence. Witness, for example, the seemingly endless debate in the United States on whether capital punishment actually reduces the incidence of the most serious violent crimes. But it's generally accepted that some significant level of deterrence is achieved when the pursuit of justice strengthens the perception of would-be criminals of the likelihood of being caught and punished. I prosecuted, as David mentioned, World War II Nazi cases, albeit as civil denaturalization and removal or deportation actions, given that the Constitution didn't permit us to prosecute criminally in the absence of a federal criminal statute that pertained and was on the books during World War II. So I prosecuted those cases from 1980, when, as a newly minted attorney, I was co-counsel on the case of former Auschwitz-Birkenau SS man Hans Lipschitz, who became the first Nazi perpetrator ever deported by the United States to Europe, all the way up to 2020, when, as David mentioned, I co-tried our last case against a former guard at a subcamp of the infamous Neuengamme concentration camp in Germany, whom our ICE colleagues deported to Germany the next year. During that nearly 40-year period, I thought from time to time about deterrence, and especially as the average age of our Nazi defendants climbed from mid to late 60s, yikes, where I am now, to the 80s. I used to fantasize that somewhere, someone who was struggling to decide whether to obey a criminal order to, for example, commit torture or participate in a mass killing, would suddenly remember having seen on TV or in a newspaper an image of some white-haired senior citizen being hauled into court in the United States or Germany to answer for what they had done during Hitler's genocidal reign of terror decades earlier. And maybe that person in my fantasy would realize that if he obeyed his unlawful orders, or she obeyed her unlawful orders, they'd have to spend the rest of their life, even into old age, looking over their shoulder, wondering whether the law was finally catching up with them. Has that ever happened? We'll likely never know. And I know what you're thinking, Rosenbaum, you need to work on developing a better fantasy life. Maybe in retirement, I can do that. After Attorney General Garland appointed me in June 2022 to coordinate the Justice Department's accountability efforts in the wake of Russia's invasion and atrocity crimes in Ukraine, I began to think much more often about deterrence for the simple reason that, unlike the cases I had worked on involving Nazi crimes, genocide in Rwanda, mass killings in 1980s Guatemala, and the others, in the case of Russia, the atrocity crimes were and are ongoing. Hence, the quest for deterrence has had a unique urgency, at least in my career, not in David's, actually. And the goal, of course, is to bring a stop to crimes that are being committed by Russia on a daily basis, even as we meet here right now. Prior to the post-World War II trials of Axis criminals at Nuremberg, Tokyo, and elsewhere, there was almost no possibility that any perpetrator would be prosecuted for such crimes. And you probably won't be surprised, therefore, to learn that in my questioning of, and my colleagues' questionings of former SS men and other Nazi perpetrators, we almost never encountered anyone who indicated that they had given any thought to trying to find a way out of participating. They had, after all, no fear of prosecution back then. Some of them claimed that they did have one fear, namely that of being killed by their own officers, put to death by their own officers if they declined to participate. But we were able to establish in our cases that those claims were factually meritless. Over the decades, I had the unforgettable experience of meeting dozens of men and women who built and prosecuted cases at the Nuremberg trials. Virtually all of them shared the hope that the trials would establish law as a nearly unfailing deterrent for international crimes. Tragically, that didn't happen, of course, as a shocked world has seen in Cambodia, Rwanda, the former Yugoslavia, Guatemala, and more than a few other countries, including in Saddam Hussein's invasion of Kuwait and Russia's ongoing aggression, war crimes, crimes against humanity, and quite possibly genocide against Ukraine. Most recently, as David mentioned, in December, we indicted 4 Russia-affiliated military personnel on war crimes charges. Stay tuned. Why did deterrence through law fail so often after Nuremberg and Tokyo? I think that the main explanation can be found in 3 words: the Cold War. Not long after the Hot War ended in Europe and the Pacific in 1945, East and West began to refocus their attentions on one another. In particular, each side saw its part of occupied Germany as the front line in their new superpower rivalry. The Nazi trials were very unpopular in Germany for obvious reasons, and in hopes of building support and loyalty, the Western allies and the Russians largely brought the trials to an end by around 1950. The result was that the vast majority of Nazi perpetrators were never brought to justice. And once it became clear that the great powers also would not permit any additional international criminal trials, tribunals to be established, the foundation of deterrence, namely the existence of a high likelihood of apprehension and punishment, all but evaporated. I'll never forget seeing a formerly classified 1948 British cable in which His Majesty's government advised that trials in the British occupation zone would, in light of quote unquote political developments in Europe, soon be ended. The cable candidly stated that it was now, quote, necessary to dispose of the past as soon as possible, close quote. You can see why they classified it, I guess. When the Cold War ended, over 4 decades later with the dissolution of the Soviet Union in 1991, political space finally opened that permitted, at long last, the creation of international and hybrid criminal tribunals with the support, or at least the non-objection, of Russia, China, and the United States and its allies. International tribunals for individual conflicts were established, and then in 2002, the International Criminal Court was established. Hopes were at last renewed, now 22 years ago, that law could play a major role in deterring the commission of international crimes, starting with the crime that makes so many of the others possible in the first instance, aggression, which the Nuremberg Tribunal termed, quote, the supreme international crime. Those were heady times indeed. I should note that David was personally involved in setting up a number of those tribunals and led the U.S. negotiating team in talks on creating the ICC. My DOJ colleague and friend, Ken Harris, was one of the Americans who worked with David on negotiating and writing, really, the ICC statute. Anyway, those were heady times indeed. But once again, politics intervened to undercut full deterrence. For example, the United States unsigned the Rome Statute as soon as President Clinton left office. And the statute's aggression provisions weren't operationalized until 2018. And even then, they were really made unenforceable except against nationals of a state that's agreed to be subject to ICC jurisdiction over aggression, which less than 50 nations have agreed to thus far, or in the absence of such consent, with the approval of the United Nations Security Council. But offenders like the Russian Federation possess veto power in the Security Council. Moreover, some ICC member nations have refused to arrest suspects and send them to The Hague for prosecution. This happened most notoriously when South Africa refused to arrest former Sudanese dictator Omar al-Bashir in 2015 when he came to South Africa to attend a meeting of the African Union. The ICC had issued warrants for Bashir's arrest on war crimes and crimes against humanity charges in 2009, and then on genocide charges in 2010. As an ICC state party, South Africa was legally obligated to arrest him and send him to The Hague, but they didn't. One more example, the United States and many like-minded nations have agreed to create a special international or perhaps internationalized tribunal to prosecute the crime of aggression committed against Ukraine. But the tribunal still has not been established as discussions drag on about modality, procedures, and the like. Meanwhile, Russia's aggression continues to kill and maim thousands upon thousands of Ukrainian men, women, children, and babies as Vladimir Putin visits death and destruction of a magnitude not seen in Europe since the days of Adolf Hitler and his erstwhile ally, Joseph Stalin. And that's quite a trio of European monsters in which the Russian president is now guaranteed to go down in history, right? Hitler, Stalin, and Putin. I would submit that respect for international criminal law has also suffered in recent years from its abuse by disingenuous political leaders. For example, by Vladimir Putin, when he has outrageously justified his unlawful, full-scale, unprovoked invasion of Ukraine by claiming that that lethal assault is necessary in order to stop Kyiv's supposed genocide of Ukraine's ethnic Russian population, and equally incredibly, to denazify Ukraine. It's the height of audacity for a man under whose leadership Russia has replicated some of the large-scale atrocities perpetrated by the Hitler regime the last time that Ukraine was invaded, to claim that denazification of Ukraine is a justification for what his government is doing. Another example is South Africa's recent referral of Israel to the International Court of Justice for ostensibly committing, of all crimes, genocide in Gaza during the war that Hamas launched with a genuinely genocidal mass homicide attack last October 7 that resulted in the largest single-day murder of Jews since the Holocaust, with more than 1,200 victims. Hamas spared no one from murder, mutilation, and kidnapping, from babies to elderly Holocaust survivors. Spain's accusation is a perversion of both the law and the facts. Ruth Marcus's January 26 column in the Washington Post is one of the best succinct explanations of why the genocide charge is baseless. She might also have quoted White House spokesman Admiral John Kirby, who pointed out on December 18 that Israel has agreed to humanitarian pauses and to the delivery of humanitarian aid, and even has issued information publicly on where it planned to attack and which locations were safer. As Admiral Kirby put it, quote, "That's basically telegraphing your punches, and there's very few modern militaries in the world that would do that. I don't know," he continued, "that we would do that, to put a map out there and say, hey, here's where you can go, where it's safe, and here's where you shouldn't go because we might be striking there." Permit me to add, and I guess you're seeing that a main subject of my remarks is two imperiled democracies, Israel and Ukraine. But I want to add that on the basis of having devoted my professional life for over 40 years to studying, investigating, and prosecuting World War II Nazi crimes, including questioning scores of perpetrators and witnesses, and learning from dozens of former Nuremberg staff members, and from hundreds of US, German, and other court decisions in those cases, I am convinced that Hamas, an avowedly genocidal terrorist death cult that opposes, by the way, the so-called two-state solution, did something beginning on October 7 that I never imagined I would live to see anywhere. They have actually outdone the Nazis. Imagine that, outdone the Nazis in systematic, sadistic, and gruesome brutality, in reveling openly in their butchery, including through grisly cell phone videos, and in promising more of the same. Anyone who doubts this should read, among other sources, the deeply shocking graphic account in the New York Times on December 28 of sexual violence, including mutilation of women. If I were to read aloud from that article, YouTube might take down the video of this session if ASU were to post it. These kinds of abuses of international criminal laws are undermining confidence in its impartiality and even in its utility, ironically, just as the need for enforcement of those laws is becoming ever more important and urgent. So international criminal law is being stress tested now, as perhaps never before, and it plainly has been found wanting thus far as anything close to a complete deterrent. Do I think that hope is lost for law as a deterrent to international crimes? No, certainly not. Though I think that other tools will continue to be necessary as well. The kinds of tools that are subject of a great deal of study and teaching here at ASU, such as skilled diplomacy, public warnings, imposition of well-calibrated financial and other national government sanctions, intensive intelligence collection focused on potential future outbreaks of widespread atrocity crimes, expanded investigation and reporting by journalists and NGOs, and imposition of measures calculated to inflict reputational costs, such as barring offender nations from participating in Olympic Games. And sadly, the implicit or explicit threat or even the use of military force or intervention by armed peacekeepers will certainly have to remain in the response and deterrence arsenal for the foreseeable future. On the military side of deterrence, the free world has an obligation, I think, to do what is possible to ensure that imperiled peoples have the means to defend themselves against aggression and other international crimes. Nowhere is this more evident than in Ukraine. Vladimir Putin's ambitions to conquer Ukraine, and I suspect other European countries, pose the greatest threat to world peace and security, and to US national security as well, that we've seen in generations. Ukraine's fighting forces, mostly just ordinary citizens, men and women who've come forward to bravely defend their homeland, are taking on the massively equipped and much larger Russian military, paying a huge price in blood. A European democracy is fighting against a ruthless dictatorship for its very survival and isn't even asking for us to send our own troops to fight alongside them, but only seeks replenishment of armaments. And the US isn't fully coming through for them? For shame, for shame. Thank goodness, by the way, France didn't back down from spending to support American colonial forces as they fought their own existential battle for independence against the mighty British military during the American Revolutionary War, or else there would be no United States of America today, and we'd all be speaking with British accents. Perhaps it's time to bring back a word that regularly appears in ancient religious texts, but that one hardly ever hears anymore: wickedness. But what Vladimir Putin is doing to Ukraine isn't just wrong, or bad, criminal. It's wicked. And anyone in Congress or elsewhere who fails to stand up to wickedness when they have the power to do so helps to ensure the persistence of that ultimate evil. As Holocaust survivor and Nobel laureate, Peace Prize laureate, Elie Wiesel famously said, quote, "The opposite of love is not hate, it's indifference." As for the continued role of law in deterrence going forward, I think several priorities can be identified. First, in the area of international criminal law, investigation and prosecution need to be ramped up. This will require expanding international cooperation and increasing the financial and human resources made available for the work. Good models for this are the Genocide Network, hosted at Eurojust in The Hague, and the recently established International Center for the Prosecution of Aggression Against Ukraine, also in The Hague. The United States, including DOJ, participates actively in both entities. We must also hope that the Aggression Tribunal is stood up shortly and that the ICC is able to bring numerous additional cases arising out of multiple conflicts. On the domestic law side, the statutory tool chest in some countries is incomplete. Those gaps should be filled as soon as possible, and statutory authorities should be tenaciously employed. In the United States, a bipartisan effort led by Senators Grassley, Durham, and Graham succeeded in December 2002 in giving the United States, at long last, present in jurisdiction in war crimes cases. Some of us, David among them, worked on that goal for more than a decade, all the way back to the Obama administration. The bill, signed a year ago by President Biden, ensures that war criminals from Russia or elsewhere who dare to set foot in our country can be prosecuted here. But other statutory tools are lacking in some countries, such as in the United States and Italy, which are the only two NATO countries that still don't have a crimes against humanity criminal law. Also, national financial sanctions and visa restrictions need to be imposed wherever possible by all nations that have the power to do so in order to promote deterrence and accountability. In the Russia-Ukraine context, the US Departments of State and Justice have clearly taken the lead. In addition, I believe, The work of legal scholars and NGOs must continue unabated. One thing I haven't seen but would like to see is for experts to research and publish in detail now how a legal reckoning might occur someday in post-Putin Russia. They might pointedly invoke the history of post-Hitler Germany, where prosecutions continue to this day, nearly 80 years after the defeat of Nazi Germany. Russian officials and military personnel are, after all, violating not only international criminal law, but also domestic Russian law, including the country's own laws of war. Those who have taken or ruined the lives of literally hundreds of thousands of Russian soldiers and their families and have squandered a vast national fortune in order to conquer a peaceful neighbor may find that one day a fully informed Russian populace demands accountability. Already, according to an essay published recently by CIA Director William Burns, quote, "Disaffection with the war is continuing to gnaw away at the Russian leadership and the Russian people beneath the thick surface of state propaganda and repression." Anyway, experts in Russian law in the free world can produce legal solutions now that will be ready for immediate implementation in Russia when circumstances permit. And finally, I have in mind what I might refer to, due to lack of creativity on my part, as international administrative law, especially at the United Nations. And now you will certainly see that I am retired and do not speak for the US government. The free world has to act resolutely, and I would say boldly, especially at the UN. Russia is the most pressing case. Its leaders continue to ignore a March 2, 2002 General Assembly resolution passed by a lopsided vote of 141-7, calling on it to withdraw its forces from Ukraine, where it violates every day the fundamental requirement of the United Nations Charter, namely that nations may not employ force or the threat of force against the territorial integrity or political independence of other nations. And Russia continues to ignore a March 2022 ruling of the UN's International Court of Justice that Russia, quote, "shall immediately suspend the military operations that it commenced on 24 February, close quote. The Kremlin's criminal aggressions are contrary to the core goals of the United Nations of preventing war and maintaining respect for internationally recognized, internationally guaranteed human rights. The General Assembly recognized this fact when it expelled Russia from the UN Human Rights Council in April 2022. Yet Russia continues to be a veto-wielding permanent member of the UN Security Council. This outrageous situation undermines the effectiveness and reputation of the United Nations. As we approach the 2-year anniversary of Russia's brutal full-scale invasion of its peaceful neighbor, serious consideration should be given to warning the Kremlin that its so-called P5 status at the Security Council may at last be in jeopardy. Professor Thomas Grant of Cambridge University has published several excellent how-to pieces on a veto-proof methodology for expelling Russia from the Security Council. And he points out that there's precedent for such action when Beijing was given the UN and Security Council seats in 1971 that had always been filled by the Republic of China, Taiwan. Most important is the fact that Russia has violated the December 1991 agreement under which it was permitted to fill the former Soviet Union's seats. Under that agreement, Moscow promised to abide by the UN Charter, specifically including respecting the sovereignty and territorial integrity of neighboring countries. Moscow has undeniably breached this agreement, particularly through its invasions of Georgia and Ukraine. There is, accordingly, no longer any legal basis for Russia's continued presence on the Security Council, a status that I would note is also fundamental to what remains of Russia's prestige, both internationally and domestically, and that enables it to continue to block multinational action geared toward building a peaceful world order and ensuring the primacy of the rule of law. It is long past time, in my personal view, to start the conversation about potentially ending the empowerment of an outlaw state. That's what Russia has now become. Ending the empowerment of an outlaw state as a veto-wielding leading UN member state, or for that matter, continued treatment as a normal member of the community of nations. Once that conversation begins in earnest, we can be sure that other nations, like China, as it perhaps ponders the possibility of launching military action to conquer Taiwan, will take notice. In conclusion, the foundation exists to bolster the power of criminal law to deter international crimes, but there's much work that remains to be done. And when one considers that those crimes include the worst offenses known to humankind, and that their continued perpetration threatens world peace and security and countless lives, time, of course, is of the essence. Thank you. Right.
Thank you so much, Eli. That was a tremendous talk, and you raised
Tremendously long.
but you raised so many interesting issues. And I do want to just get a little granular with you. Would you share with us what you consider to be your most difficult case during your career in bringing a Nazi suspect to justice, either through deportation or otherwise, in federal courts?
Sure. If I can be permitted to mention two such cases. One was the very long-running case of John Demjanjuk, a death camp guard who served at the Sobibor death camp. If I were to even summarize that case, it would take another hour, so I won't, but you can look it up if you're not familiar with it. When we finally won an order of removal against him, I remember being on the phone with one of his lawyers who said, look, you all have won every legal battle so far, but you'll never get my client out of the United States because no country will agree to accept him. And my heart sank because I knew that that had been a problem in so many of our cases, and the thought that it would happen now in our highest profile case involving a man who was part of the machinery of annihilation at the Sobibor death camp, where hundreds of thousands of innocent people, Jews, had been murdered and then incinerated, was very hard for me to accept. I also knew something that I couldn't share with the lawyer, which is that Germany had already told us that they were not going to accept him as a deportee. We finally got around that problem. We surmounted it by working with a few really dedicated investigative magistrates in Germany. Eventually, the work that Kirsten Goetz and Thomas Walter did in partnership with our office persuaded the state prosecution office in Munich, Germany, to charge Demjanjuk with multiple murders. And of course, once Demjanjuk was now wanted in Germany, the federal authorities in Berlin, who had blocked accepting him as a deportee, had to change their position and say, of course, we'll accept him. He was accepted. He was put on trial, and I think in 2011 or thereabouts, he was convicted. But that was a multi-year effort at a time when Demjanjuk was already now quite old, and we were kind of racing against the Grim Reaper. And for once, the Grim Reaper lost. The other case I have in mind is that of Alexandros Stalaikis, whom we found in Norwood, Massachusetts, who during World War II was the chief of the Lithuanian security police for all of Vilnius region. And the security police, that was the Lithuanian analog to the Gestapo. They worked shoulder to shoulder with the SS, including in arresting Jews and sending them to giant pits outside the wooded hamlet of Panarai, as it's known in Lithuanian, Panari, I think in Polish, Panar in Yiddish, where some 50,000 Jewish men, women, and children were shot to death, leaving very few survivors in Vilnius. We found him. We couldn't find any documents implicating him in crimes. When I interviewed him as a young attorney, he readily admitted that he had that job, but he said it was just routine police work. And he had nothing to do with Jews. And that was maybe 1982 or so. And it wasn't until the Soviet Union collapsed in 1991 that we could get, or was about to collapse maybe in 1990, that we were able to get one of our brilliant historians, Michael McQueen, into archives in Vilnius, where he found document after document signed by Leleikis, sending Jews to their deaths at Panari. And Leleikis was the oldest person we'd ever charged. Was, I think, 88 years old. Time was against us, but we won our citizenship case on summary judgment, and then we won our removal case in immigration court. But the Lithuanians, and I should say, to my surprise, Lithuania took him. They had routinely refused to take such people. And according to public reporting, Leleikis had secured some sort of promise that if he returned, he would not be prosecuted. That's pretty much consistent with Lithuania's approach to Nazi cases. There are none left, but they did not want to prosecute those people. They wanted to prosecute Soviet war criminals only. Leleikis did go home, and they did not put him on trial. Finally, under a lot of political pressure from the United States, they did put him on trial, but he didn't even get through the first day. He reached for his heart, claimed that he was having a heart attack. Coincidentally, there was an ambulance outside the courthouse, and the trial never resumed. The judge refused to agree to have Leleikis examined by an international panel of physicians, and he lived for quite a while longer, managed to write his autobiography during that period and get it published, but he wasn't physically fit enough to stand trial. So that was incredibly frustrating.
And Eli, I took particular note with great understanding of your comments on October 7th and what has transpired there with respect to the Israeli people, the worst assault since the Holocaust. If you were, I'm going to put you a little bit on the spot here, if you had a chance to sit down with the military staff of the Israeli Defense Forces, confidentially, privately, is there anything you would say to them today after the last 3 months about how you think they should continue to be conducting their military operations in Gaza so that they don't fall into any sort of liability trap under international criminal law? What would you say privately if you'd like to disclose that to us?
Well, I don't think they would seek my advice on this, but from what I've seen in public reporting, since I no longer have access to government materials, they have a battery of lawyers who give approval for specific operations. You know, they are, as you mentioned in your excellent NPR interview, having to work in battle situations in which Hamas terrorists or fighters or militants, as the Washington Post calls them, in the same issue in which ISIS will be referred to as terrorists, Hamas is referred to as militants and fighters. I can't understand that. But anyway, they're hiding behind civilians, both Palestinian Arab civilians and hostages, which is itself a war crime, creating a nearly impossible situation for Israel to respond to defend its people against the existential threat posed by Hamas and in the north, Hezbollah and their Iranian backers and the Houthis, etc. I think they are likely doing the best that can be done under these circumstances. I think my advice to them would be perhaps to be more transparent about what they're doing to protect civilian life, to get better spokespersons who can perhaps recapture some of the narrative that's obviously turned against them. You know, because of the fact that the first couple of decades of my career were spent on Nazi cases, and I kept working on those, you know, through 2021, I tend to see a lot of things through the lens of World War II. And this is an example. And, you know, I wonder if before World War II, instead of in 1948, after the war, the UN had said, okay, we're going to establish a state for the Jews, but it's not going to be in Palestine, where Jews have lived, you know, for thousands of years, but rather it's going to be in Europe. And we're going to locate it, sorry to say, right next to Germany. And so that's where the Jews go. And early on, they learned that Hitler has in mind complete extermination of all 11 million Jews living in Europe. In the end, we know in hindsight, he managed to kill 6 million of them. And the question is, what should the Jews in that other Israel do? One would hope that they would attack and prevent the launching of the genocidal war, or once it starts, they would attack and try to end it. Of course, it was the Allied victory over the Nazis that, albeit too late, accomplished that goal. I would note that, I hope I have my numbers right, I think Allied aerial bombardment killed over 300,000, maybe much higher than that, 300,000 German civilians, and that's of course only to be regretted. But this is what happens in war. The moral of the story: don't launch a war, and especially don't launch a genocidal war of atrocities. I would say also that the Israeli government should reiterate that there can be a permanent ceasefire tonight. And all that has to happen is for Hamas to do what we insisted, the Allies insisted Germany and Imperial Japan do in World War II, namely surrender unconditionally, come out with your hands up, give up your prisoners. Then there's ceasefire tomorrow. I would say, well, I'll leave it at that for now.
Thank you, Eli, very much. I want to open it up to questions from our audience, as well as Ashley, if you could keep track of virtual questions and bring them to me. Anyone in the audience with a question? Yes, in the back here.
I guess on that note, I have a lot of questions about what Hamas wants with the ceasefire, and why Israel would be willing to give hundreds of prisoners for just a few of the hostages.
I'm sorry, where?
Oh, I'm sorry. I'm wondering why Israel, I know they didn't take the ceasefire deal, but why have they done it before, and why would they entertain swapping hundreds of Palestinians, or really terrorists who are in their prisons, for just a few of the hostages?
Well, you know, as you say, they've done it before, and the reason is there are these are innocent people who are loved by their families, and the Israeli government takes very seriously its obligation to protect its citizens. There is a saying that exists both in Jewish tradition and in Muslim tradition that who saves one life has saved an entire world. The problem is Hamas doesn't operate under that principle. They, from all appearances, they undertook this war of atrocity specifically because they knew that it would generate an overwhelming military response from Israel, and that since they were hiding behind civilians and locating their rockets and other armaments in civilian areas would lead to a large loss of life on the part of civilians, as of course came true, and that would turn the world against Israel. It would also help to dissuade the many Israelis who favor a two-state solution from continuing on that course. And it's had some success there as well. Hamas favors a one-state solution in which, according to their founding charter, no Jews are left alive.
Yes.
Example, which actually, to my chagrin, having been ambassador in Estonia nearby, I was not aware of that particular instance. Would you give us a little bit more background, because it relates to what's going on right now as well? Of course, none of this stuff really ever goes away in terms of human rights. Why, given the close relationship between us and the three Baltic states, in this case, the United States was not able to prevail on Lithuania to take much more aggressive action against this war criminal and to allow this sort of sliding by to occur? Give us a little bit of a sense as to why.
And honestly, this was a problem that we had with pretty much every country of Europe with which we dealt in these cases. Germany, Austria, all three Baltic nations, Romania, Poland. These cases are often embarrassing to the government. So they really wanted to avoid them. And in my discussions with officials in some of those countries, I would typically say, I understand it, you know, every country, and I'm going to say maybe except Iceland, I don't know, just about every country has bad things, really bad things in its past that it would prefer not to be reminded of. And the closer in time those bad events are, the more, and it's only natural, I suppose, in some sense, that the subject is to be avoided. Also, the Baltic countries were trying to get into NATO at the time, and reminding the world that there were collaborators there who assisted the Nazis in perpetrating genocide and other crimes was not particularly helpful. But I would also say to them, and I say it here, that the United States is no exception to that trend. Here we are in the year 2024, so many decades after the Civil War ended, and there are still so many people in our country who refuse to accept the reality that that war was fought over slavery, over the owning of other human beings. Imagine that. So we've seen it in many places.
If I may, just for one more, I don't want to
Certainly, Mr.
dominate this, but so would you say, because I understand exactly what you're talking about in terms of the receiving country's reluctance and the reasons that those all makes absolute sense. But you just addressed the one area where I would have given us the blame, and that is not pushing even harder, because your incredible work that you have done and the commitment of our country that we have stated in terms of the values that we stand for and that we want to pursue, that we would not have been able to insist that Lithuania in this case, and you can insert other country name if you wish.
Absolutely.
You must and you will, and we have ways to go ahead and press you. So we made a conscious decision as a country ourselves when we were going to stop stop pushing and we're going to start backing off. And of course, the entry of the Baltic countries into NATO was one of the things that was also part of US policy, and therefore that I'm sure played a role.
You know, not everyone, some of the greatest heroes in my life, like David, have worked and still work at the Department of State, like David's successor, Beth Van Schaack. But you all don't run the Department of State. So subject for another day, I think will be my disappointment over how the State Department handled those cases. If I may tell a quick story about how this played out in another country. Back in the mid-1990s, we investigated the possibility that Japanese war criminals from World War II would come to the United States. And it appears that they didn't. And for good reason, there was no mass immigration from Japan to the United States as there was from Europe. But we decided to bar from entering the United States people who took part in war crimes. And the Japanese government, alone among the countries of the world from which we sought assistance, declined to allow us access into their key archives, for instance. But on our own, we identified some number of participants in the in Japanese military's medical experiments and in the so-called comfort women crimes of the Japanese military. I don't like that expression, but that's the one that even the NGOs that work on the behalf of the survivors use. It really should be comfort women and girls. Some of them were well underage. And so we did that, and we decided to make it public, and we wrote a Justice Department press release. The department was prepared to issue it, as they had done in other similar situations involving German crimes. And I thought, well, I better notify the State Department because Japan was not forced fully to confront its past the way Germany was. And I think we should give state the heads up on that. So I did. And I get a call asking me to come over. And I met with a senior State Department official handling Asian and Pacific affairs or something. And he looked at the press. He said, oh, well, I've looked at your release and there's a problem. What's the problem? He said, you refer to rapes. I said, yeah, we refer to rapes and murders and other crimes committed, kidnapping, other crimes committed against these women and girls. He said, you know, but in Japan, when the comfort women cases are discussed, and of course, there were many people in Japan, including officials of different parties who denied that these crimes even took place. But when it's discussed, they don't use the word rape. That's a charged word, and it will be very upsetting in Japan. And I said, well, you know, forgive me, I'm a prosecutor, and we deal with crimes, and that's the key crime that was committed here, mass rape. And we went back and forth for a while. You'll enjoy this, David. And I was very brash back then. And I finally said, look, it seems that we're not going to reach agreement here on the wording of the release. So why don't we send this up the respective flagpoles of our two agencies and see how Secretary of State Madeleine Albright and Attorney General Janet Reno feel about using the R word. Now, I wouldn't normally use the first names of agency heads, but I thought in this instance, it was instructive. And he immediately backed down and he said, how about one use of the R word? I said, sold. But all countries, as I say, have painful and difficult issues in their past. Again, sorry to Iceland.
Thank you. An excellent tactic, by the way. Good for you.
Thank you.
Ashley, did you have something? Oh,
Ben, frankly, thank you for your presentation. Back to
Thank you, John.
deterrence. There's an element of deterrence about will. People have to be willing to recognize that they can be held accountable. Do you feel like there's been sufficient awareness to nations that may not have a Western view? In Myanmar with the military junta, or even with the Chinese, is there sufficient global recognition of accountability? And that people can and will be, hopefully, held accountable for illegal actions. What are your thoughts there?
I think it's been a slow process, but it's been improving, as witnessed by the fact that, did I say was the number 141? To 7, the UN General Assembly condemned what Russia was doing. You know, one of the leading powers in the world, a country that most UN member states don't particularly care to antagonize, but they did it. So slowly but surely, we're getting there. Having said that, I'm reminded that in July of 2022, when I went to The Hague with Beth Van Skak, I know 2 colleagues from her office here, to the first Ukraine Accountability Conference in The Hague. There were, forgot the number now, 44 or something like that, nations that attended and signed the declaration calling on Russia to withdraw from Ukraine, calling on pursuit of the perpetrators, calling for the pursuit of perpetrators. There were hardly any countries from the global South represented. And I'm pretty sure that the Netherlands government in particular, as the host, had tried hard to bring in additional countries. I think if that were held today, you'd have better attendance.
Thank you.
But I totally agree, John.
I think we'll make this our last question. It comes from the virtual world, Bruce Pagel, asking, what is your realistic assessment Putin ever being prosecuted for the crime of aggression, notwithstanding a strong interest in doing so and multiple efforts to establish jurisdiction? I mean, there's so much that has been undertaken, as you know, since February 2022 to enable a prosecution on the crime of aggression, and we're not there yet. But how would you answer that? First, are we ever going to get there? And even if we do, what are the prospects of actually prosecuting him on that crime?
Great question out of Tempe, as I would expect. I think the prospects for prosecuting Vladimir Putin are much higher than President Putin imagines. Things can change very quickly, as you know better than I. It could easily happen one day that he's out of office and still alive, and that his government is succeeded by a moderate government, a government that appreciates the horror of, so to speak, of what the Putin regime inflicted on both Ukraine and Russia, and decides either to prosecute him in Russia or even to send him to this still to be created tribunal, or even at that point to the ICC, since he's no longer a president. And Russia might consent to ICC jurisdiction. So I think this is something that Vladimir Putin ought to be worrying about. And of course, the most important thing he could do is comport himself like a decent human being and call off the invasion, but he won't.
So on a slightly lighter note, I do have a final question myself. What are you going to do for the rest of your life, Eli?
That's a great question. I expect to join my wife on vacations, which I have hardly done in the last 40 years. She goes with her best friend. I always say I'm going to catch up on a lot of reading, including your latest book, and I'm going to watch some television. I always say I'm told that television is transmitted now in color, but I haven't actually seen it. So we'll see. I hope to do some writing and to make use of this newly restored, after 36 years, freedom of speech.
Great.
Thank you all so much.